Now, I have indicated that nobody wins or loses a divorce, and I believe that. But one person can have a much better result than the other person if they make their decisions wisely. Your lawyer, if he's shrewd, if he's smart, and if he works, and if you have good facts and a good case, can, quote, defeat the other side. I don't know of any lawyers that can defeat the bad guys and the good guys. Once you retain your lawyer, unless it is a absolute walk-through divorce, total apathy by both parties, they both want the divorce, and they both want it over with quickly, which is good circumstances that occur. It's rare, but it does happen. Let your lawyer do the negotiations. It does no good for you to spend a lot of money on a lawyer to set up a strategy, a settlement posture, and then think you can do an end run and go around and settle the case yourself. All you do is undermine the power of your attorney and undermine your case and increase your fees. Especially in controlling relationships where narcissism or parental alienation is involved. When that is a core issue in the case, if one of the spouses that is participating in this terrible behavior sees the hammer coming, he will frequently go to the other party. I'm sorry, here are the flowers. I'm sorry, you can have the children again. I'm sorry, here's a check. These lawyers are charging us a fortune. Let's just get this over with. And 2 hours later, you've given your case away, and all the work your lawyer's done, and all of the preparatory work for a good hearing, a good judge result, or a good jury result is undermined. Don't undermine your attorney. If you don't trust him, get a new lawyer. In the state of Texas, you can fire a lawyer for any reason you want. You don't have to have a reason. But if you do trust him and use him, use him. Don't try to be a lawyer. You'll increase the cost of your case, and you will lose a lot of initiative and benefit that your lawyer has worked so hard for you to obtain up to that time. Once an order has been entered on a preliminary hearing and the discovery is done, if the case can't be settled, almost all courts today require mediation. Mediation is a process where you meet and a third party does not arbitrate. It's not, his decision is binding, but if you're smart in your choice, he's skilled at bringing parties reasonable closure on items that are the worst and most difficult to close on. And he's not bound to listen to your lawyer or the other lawyer. He speaks with both. You meet in a caucus, jointly, generally, and he puts out the perimeters of the mediation. Then you adjourn to separate caucuses in separate rooms. And as Henry Kissinger in the Arab-Israeli-Palestinian conflict, he does shuttle diplomacy. And he goes back and forth to point out the weaknesses of your case, the strengths of the other person's case, and try to bring closure to the case. Mediations are very successful. The settlement rate is in the 90s, depending on your mediator. But it is a very instructive tool that is adversary but not adversary. It's not under oath, and nobody is having to stare at a jury or a judge, and you can tell your story to the mediator, and if a resolution is made, you will have saved yourself significant sums of money in attorney's fees, and you saved your heart significant pain in an ongoing divorce. Should mediation fail, there are a number of pretrial matters that occur, and then depending upon whether you have a jury or a judge, you have a trial. The judge will make a ruling, and he won't have all the information, and in today's world, the crowded dockets, most judges have pretty strict time limitations, so you're going to have to be very concise in presenting your evidence, but he will rule, and that will bring closure to your case subject to appeal.
Nacol Law Firm, may I help you?